about what they call the criticism of force of judgment regime. That paper ought not to even have come before paper 18. But we will allow them to come after paper 18. After paper 18, if they will concentrate only on what they call that part of their paper that they call Cogmire, I guess that is where they are trying to criticize the Nigerian the judicial approaches, judicial and legislative approaches to enforcement of judgment. We see what we can get from their presentation, which is going to be very important to our knowledge of the subject area. Paper 18, which will come before paper 17, is going to talk about the cases. I have read through paper 18. It's just like they reproduce my own work on in Commonwealth Law Bulletin. Nevertheless, for the purpose of the class, we just let them present it that way. But they should know that when you copy a person's paper and present it to him, you cannot score high mark for assessment. I will assess their paper, but I just hope that what they copied, they also understood it. Because I read through their paper and I saw their separate treatment of Professor Olawoyin's critique of one particular case, is it Verb Oil or whatever, or Verb Petroleum or whatever. If they had understood what I was saying, there was no need to separately discuss what Professor Olawoyin was saying, because Professor Olawoyin was saying the same thing as I was saying. Yes, Professor Ll.M is more fluid with language. I give it to him. But it's the same thing I was saying that I was saying. So there's no need, when you are looking at a case, there are about 4 cases that are on the same line. Macaulay and Azebi of Australia, marine insurance, and whatever. I discussed 3 of them. Professor Olawoyin discussed a 4th one at a later date. If you really understood what I was saying, you also group the 4 together and say that it is in the same vein that Olawoyin criticized that, but they were just copying what we said. And we hope that by the time they do their presentation, we will understand what is it that we academics are criticizing about the judicial approach. Paper 19, I have told you, there's no need for us to listen to it because they mess up the whole issue. There's no
Good evening, Prof. Sir.
Yes?
Good evening, Prof. Sir. I'm in group 19, sir.
Group 19, I have non-suited your paper because the only thing we wanted you to tell us is how to enforce sister state judgment. And what you were saying, I don't think that's what you were addressing, because there is no.
Sir, we addressed that. I earlier heard you, sir, saying that we did not speak to section 104.
What did you say about section 104? You said section 104 says they should obtain leave. Where does it say so? Go and look at section 104 and 105 very well and rewrite your paper before exam so that you can score something for presentation. I will talk to section 104 and 105. It's a brief talk. I will talk to it so that you will get everything that we mean when we talk about interstate enforcement of judgment. Then paper 20.
Thank you, sir.
Paper 20 is talking on, we are concerned mainly with enforcement of foreign arbitral award. And it is treated in Arbitration and Mediation Act. They discuss it in part 3 of their paper. So we'll give them 20 minutes to talk to part 3 of their paper. So altogether, what do we have now? We have paper 16, 20 minutes. Paper 20, 20 minutes. That's 40. Paper 18 and paper 17, 20 minutes each. 20 times 4. That is
1
80
hour,
minutes.
20 minutes.
1 hour, 20 minutes. So
Yes, sir.
paper 19 is already non-suited because the only thing we want to hear, they didn't do justice to it. I'm sorry. They would have to go through section 104 and 105 of the Act. And they cited the case of this particular case that I discussed in chapter 5 of my work. But that case has nothing to do with the enforcement of judgment. It is on service of process. So it does appear as if they are mixing issues up. They are talking about leave to serve process, whereas we are telling them to talk to us about enforcement of sister state judgment. So they should go and look at 104 and 105 very well, understand what it's saying, and see if there are cases illustrating it, and for them to do well in the seminar assessment. So let's go. Paper 16 now.
Good evening,
Paper
Prof, sir.
16, your 20 minutes start.
Yes, Prof. Good evening, Prof, sir. Good evening, Prof, sir.
Good evening.
Yes, sir. My name is Alara Oluwasegun Jonah. So we are in group 16. In group 16, we are 3 in number, sir. Myself, Alara Oluwasegun Jonah, and we also have Shaba Olakemi Olawumi. Are you in class, please?
Yes,
okay.
I am. Yes, sir. Good
Okay,
evening,
then we
everybody.
also, yes, good evening. Then we also have Judith Chukuka Azufaloye. Are you in class?
I'm in class. Good evening, Prof.
All right.
Good evening, class.
All right. Thank you very much. So, Prof, sir, the 3 of us, we split the work within ourselves. 2 people conducted the research. 1 person will be taking the presentation. So, Judith Chukuka Azufaloye will be handling the presentation, sir. So, Judith, over to you.
Thank you very much, Mr. Shegun. Good evening, Prof.
Yeah, you're welcome.
Good evening, class.
Go on, please.
Okay,
We don't
our
have time.
seminar topic is theoretical basis for recognition and enforcement of foreign judgments. The meaning of foreign judgment, without wasting the time of the class, according to our paper, the concept of a foreign judgment revolves around the court's decision emanating from outside the territorial boundaries of Nigeria. Section 2 of the Foreign Judgments Reciprocal Enforcement Act 1961 defines a judgment as an order made by a court in civil proceedings, extending to arbitration awards that under the applicable law of the place where they were made have become enforceable in the same manner as a court judgment. It includes judgments or orders from criminal proceedings mandating the payment of compensation or damages to an injured party. Before a foreign judgment can have any teeth in Nigeria, it must be both recognized and enforced. As Atayebe rightly points out, recognition and enforcement are distinct yet interconnected processes. A judgment can be recognized without being enforced, and enforcement itself can imply recognition. Enforcement, as Shira E.R. explains, is the procedural mechanism by which a judgment or order delivered by a court in one nation is given effect in another. The necessity for such a mechanism becomes evident when considering the practical challenges of compelling compliance across international borders. The Supreme Court of Nigeria in Marine and General Assurance Company PLC versus Overseas Union Insurance Limited and others addressed the enforceability of foreign judgment within the context of the Reciprocal Enforcement of Foreign Judgment Ordinance and Foreign Judgment Reciprocal Enforcement Acts. The court emphasized that the judgment must be deemed conclusive between the parties in Nigeria, and that the stipulated conditions within the enabling legislation must be satisfied for enforcement. This underscores the crucial importance of adherence to the statutory framework and established legal principles. The principles governing the recognition of foreign judgments were thoroughly examined by the Supreme Court in Andrew Macaulay and referencing Central Bank Ostrich, Akingelskraft, RZB of Austria. The court reiterated that this Reciprocal Enforcement of Judgment Act applies to foreign judgments and that the judgment must be registered within a specified period. Crucially, it emphasized that the lack of jurisdiction of the original foreign court.
Move, my sister, move. Theoretical basis now. Go to theoretical basis. You have told us what a foreign judgment is.
Okay,
Our statute
discussion on the theoretical frameworks. Yes, it is important to consider the principle of territorial sovereignty that justifies the limited effect of a judgment in one court rendered by another court. The principle of territorial sovereignty can be understood from two aspects, internal and external. From the internal perspective, a sovereign state has an exclusive right to exercise its power and authority within the boundary of its territory. In other words, any and all people, things, and transactions found within the territory will be subject to the exclusive control of the sovereign state, including its judicial powers. Accordingly, a sovereign state has the power to bring any individual found within its borders before its court and render a judgment against that individual. In this sense, a sovereign state's power is limitless. From the external perspective, which is concerned with relations, it possesses exclusive jurisdiction and sovereignty over persons and property within its territory. No state can exercise direct jurisdiction and authority over persons or property without its territory. Under the principle of territorial sovereignty, the effect of a judgment rendered by one court in a sovereign state cannot be extended into another sovereign state. This is for the reason that a judgment rendered by one sovereign state is regarded as a judicial product of that state only. Since it is announced by a court delivering its authority from that state, and the effect of the judgment is limited to the territory of the sovereign whose court rendered the judgment. While the principle of territorial sovereignty seeks to protect the supreme power of a nation, the effect of which may have an adverse impact on the recognition and enforcement of foreign judgments by the operation of the territorial sovereignty, a sovereign state cannot give effect to a judgment that is the judicial product of another sovereign state. Consequently, a strict adherence to the principle of territorial sovereignty may hamper international trade and commerce and cause a disruption to international order and harmony. We'll go straight to the theory of comity. The doctrine of comity was introduced to reconcile between the needs of international commerce, trade, and intercourse of nations on the one hand, and territorial sovereignty on the other. The comity doctrine was contained in Huber's three maxims, which are: first, the laws of each state have force within the limits of that government and bind all those subject to it, but not beyond. Second, all persons within the limits of a government, whether they live there permanently or temporarily, are deemed to be subjects thereof. And third, sovereigns will so act by way of comity that rights acquired within the limits of a government retain their force everywhere, so far as they do not cause prejudice to the powers or rights of such governments or of their subjects. While the first two maxims recognize the principle of territorial sovereignty, in which no sovereign state is under an obligation to apply foreign laws or to give effect to foreign judgments, the third maxim states that courts in one sovereign state may exercise foreign laws or give effect to foreign judgments as a matter of convenience and utility. The third maxim was created in view of the rise of multi-state transactions. Committee doctrine provides a basis, allowing courts in one sovereign state to apply foreign laws or to give effect to foreign judgment while still preserving state sovereignty. The committee doctrine was considered by the United States Supreme Court in the seminal case of Hilton and Guyatz, which involved a suit brought by a French company against its American trading partners operating in France for sums owed by the American defendants. The matter was tried in a French court, and a final judgment was awarded to the French plaintiffs. The French plaintiffs sought to have the French judgment recognized and enforced in the United States because the American defendants liquidated their assets in France. In the action for the recognition and enforcement of the French judgment, the court considered the committee doctrine and imposed the requirement that the French judgment should be given effect only if the French court gave effect to an equivalent decision of the United States court. However, the majority of the court held that since the French courts would not have given effect to an equivalent judgment by United States court, the court was under no obligation to enforce the French judgment. In reaching its decision, the Hilton Court stated that committee is neither a matter of absolute obligation nor a mere courtesy and goodwill, but it is the recognition which one nation allows within its territory to the judicial proceedings of another nation, having due regard both to international duty and convenience, and to the rights of its own citizens or of other persons who are under the protection of its laws. It follows that the notion of committee that operates on the basis of difference from sovereign states may carry the effect of reciprocity. As far as the recognition and enforcement of foreign judgment is concerned, the notion of reciprocity can take one or two forms. On the one hand, it may be used positively so that a state will accept foreign judgments and give them effect within the limits of the territory. This is done with the anticipation that foreign states will give similar reciprocity. In this sense, may have the effect of inducing courts to honor
Sorry, I'm not hearing you again. No.
can be used in a negative sense. I'm sorry, sir.
Mm.
In a negative sense. For example, if a court in a state refuses to recognize and enforce a judgment rendered by another state, a court in the latter state may do likewise by refusing to give effect to the former state's judgment, even if that judgment has satisfied all the requirements for enforcement. Reciprocity in this sense can therefore be used as a tool of retaliation against states that do not return the same favor of recognizing and enforcing foreign judgment. The Hilton decision examined earlier is an example of this negative reciprocity, where the United States Court, for want of reciprocity, refused to recognize the French judgment on the basis that French courts would not have given effect to American judgments. Then the theory of reciprocity in itself. The notion of reciprocity is endorsed as a condition for the purposes of recognition and enforcement of foreign judgments in many jurisdictions, including Australia and the European Community. In Australia, the Foreign Judgment Act 1991 states that a judgment rendered by a court of a foreign country will be entitled to recognition and enforcement in Australian courts, provided that that court would give similar effect to Australian judgments. The courts whose judgments qualify for the reciprocal treatment are specified in the Foreign Judgment Regulation 1992. In the European Community, in the light of a common market within the community, the Council Regulation EC in bracket number 44 to 2001 of 2021 December on jurisdiction and the recognition and enforcement of foreign judgments in civil and commercial matters was drafted and imposed upon each of the European Community member states. While reciprocity is imposed as a requirement for the recognition and enforcement of foreign judgment in Australia and within the European Community, the United States Court in large parts have dropped such a requirement in their treatment of foreign judgments after the Hilton and Goyat decision. It therefore rests not on the basis of reciprocity, but rather upon the persuasiveness of the foreign judgment. Similarly, as a result of the decision in Erie Railroad and Tompkins, federal courts in the United States have abandoned the reciprocity requirement for the purposes of recognition and enforcement. The notion of reciprocity has been the subject of criticism. It is argued that if a foreign judgment is refused recognition due to a lack of reciprocal arrangement with the states asked to recognize and enforce the judgment, the litigants are being punished unfairly for a governmental policy that he or she has no control of. However, there are some who view reciprocity as a means of persuading other countries to enter into reciprocal agreements for the recognition and enforcement of foreign judgment. I'll move
to doctrine of obligation.
Yes, theory of obligation. Another basis recognized to support the recognition and enforcement of foreign judgments is the obligatory theory. This theory was relied upon by the English authorities to justify the recognition and enforcement of foreign judgments since the 19th century. The obligation theory was first stated by Park B. in Russell and Smith and Williams against Jones, and later approved in Goddard and Gray, Skibby and Wettingballs, in the following words: where a court of competent jurisdiction has adjudicated a certain sum to be due from one person to another, a legal obligation arises to pay that sum, on which an action of debt to enforce the judgment may be maintained. It is in this way that the judgment of foreign and colonial courts are supported and enforced. And taking this as the principle, it seems to follow that anything which negatives the existence of that legal obligation or excuses the defendant from the performance of it must form a good defense to the action. It follows from the passage that under the obligation theory, a foreign judgment is comparable as an action of debt arising between parties in a private transaction and imposes upon the defendant a legal obligation to be answerable to that action of debt. The vested right theory was advanced on the basis that While all laws and judicial decisions are confined within its territory and cannot claim extraterritorial effects without the other sovereign state's consent, a sovereign state applies foreign laws or gives effect to foreign judgments on the basis of rights vested in those laws and judgments, and not the laws of judgments themselves. In other words, courts do not apply foreign laws or give effect to foreign judgments as such, but simply recognize and give effect to the vested rights. What
Very well.
is in fact recognized?
Very well. Your 20 minutes is gone. Okay.
Okay, so I'm rounding up in another 5 minutes, sir.
Hey, Nobo, where are we going to have that time? Let them go and read what you have presented. It's because we know what you have presented is useful that we said they should read it. Next week, we will discuss everything about enforcement of foreign judgment within the first 1 hour. Then the second hour, I will tell you what to prepare for. Okay?
Okay, sir. Thank you, sir.
So anything I tell people to present in their paper is because you need it. You need it. I will then it later for you next week. So we move to the second paper now.
Thank you, sir.
Paper 18. Paper 18. If there's anywhere in your paper where you talk about the mode of enforcement allowed under Nigerian law, talk to us about it in 5 minutes. Then the remaining 15 minutes, touch some of the critical cases, okay, that you have analyzed. Any 3, 4, or 5 cases. I saw you went through so many cases. I hope you know the cases very well. Good, so you start. First, talk to us about the mode of enforcement of enforcing foreign judgment that Nigeria has. 5 minutes. Then the remaining 15 minutes, talk about some of the cases that you analyze in your paper. I went through them. So talk to us in 15 minutes about the cases. Good. Your time starts now. Hello? Hello?
Hello, sir. Good evening, sir.
Yeah, good evening.
My name is Olalekan Ogubumi.
Yeah.
So our paper is divided into 5 parts.
I don't want to know. I'm not interested in that. Just talk to the 2 issues. What are the modes of enforcement that Nigeria recognizes? And which are the landmark cases that you reviewed? Possibly your criticism of them, if any. Those are the 2 things I want to listen to.
So the cases I referenced to. Now, the first one is the Tulu.
No, before you go to the cases, did you discuss the mode of enforcement that Nigerian law accepts? The mode of enforcement of foreign judgment that Nigerian law permits. Did you discuss? If you don't discuss it, don't worry. Maybe paper 17 discuss it.
Yes, sir. 3, we are 4. We are 3 that prepare the paper. So my own part is the part of the cases. So other presenter is going to talk on the mode of enforcement.
To let those talk on mode of enforcement start. We need to know the mode of enforcement before you go through the cases.
Good evening, sir.
Yeah, good evening.
Yes. Okay, my name is Aika Mr. Lopez. So I'll just quickly talk about the mode of enforcement.
Yes.
Okay, so there are 2 There are two major modes of enforcement of foreign judgment in Nigeria, which we've discussed in our paper. We have the registration under statutes, and we also have enforcement at common law. Under the statutes, the relevant law are the Foreign Judgment Reciprocal Enforcement Act and the 1922 ordinance, the Reciprocal Enforcement of Judgment Ordinance. So under the statutes, which I've briefly stated, usually okay, just as a brief overview, I don't know if Group 17 is also going to talk about this, but there are time limits. We have 12 months under the 1922 statutes, and we have 6 years under the act. So depending on, I know there are more conversations around this later on, but just to say that there are time limits, so you have to first be sure that the judgment is being registered within the time limit.
Did you
The first thing is,
define the common law regime? What is
yes,
the
sir, we
common law
did.
regime called? What is it called? Or how do you describe it?
Okay, so we just talked about the fact that under the common law regime, reception of English common law principles, particularly in matter of private international law, was instrumental in shaping the early legal approach in foreign judgment. And we also talk about that the Nigerian courts will enforce a foreign judgment under the common law if the judgment is final and conclusive, it was delivered by a court with competent jurisdiction, it is for a fixed or ascertainable sum of money, it is not contrary to public policy or obtained by fraud.
Did you talk about limitation of time? Is there a limitation
We talked
of
about
time?
that under the statutory regime.
No. The common law regime, does it have a limitation? Or if it does have, is the limitation different for foreign as opposed to our own court judgments? You did it, okay. You
No,
did
sir,
it,
we
or you
didn't
didn't remember where you said it. I will talk about it next week. Okay.
sir.
So the summary is that you have enlightened us that there are two ways of enforcing foreign judgment in Nigeria: the common law regime and the legislation regime. And you have told us that the legislation regime, according to the courts, are governed by two pieces of legislation: the reciprocal enforcement of foreign judgment ordinance and the Foreign Judgment Reciprocal Enforcement Act. Okay? The latter one is the one that is cap F35 Ll.M 2004, while the former is cap 175 Ll.M 1968. Good. So let the person who is talking to us about the cases, let him address us now. He has 15 more minutes to do that.
Thank you, sir.
So good evening, sir.
Yeah.
So yes, sir, I have stated series of cases. One of the cases is Tulips Nigerian Limited versus No Girl Transport Maritime. Now, what this case is talking about, this case stated is a Court of Appeal case. We stated the provision of Section 1 of the Foreign Judgment Reciprocal Act 1990. We stated clearly what a judgment is. What a judgment is, that divine judgment as an order given or made by court in any civil proceedings, or shall include an award or proceedings, or on any arbitration if award as in pursuant of the law, or enforced in the place where it is made becomes enforceable in the same manner as a judgment given by the court. And it also look at the aspect of award that fall within the contemplation of the said sections. And the court also held that such an award must be elevated to the status of a judgment, the status of a judgment of the High Court. That is, Seeking the enforcement of that judgment, the respondent in this case must seek relief of High Court of England to enforce the award in the same manner as a judgment.
Okay.
So, and also the same review from 2003 decision of the Supreme Court case in Macaulay versus RZB of Australia. So this case had turned up the time limit for applying for registration under both statutes. The 1922 ordinance prescribing 12 months and the 1961 Act prescribing 6 years. The application for registration was filed outside the 12 months, but well within the period of 6 years.
Let me ask you a question. Let me ask you a question for our education.
Yes, sir.
The legislation regimes are different in their time limit. What
Yes,
of the
sir.
common law regime? What of the common law regime?
Now,
I asked that question. It appears as if your colleague was not able to answer it.
So now the thing is, I believe that under the local practice, the enforcement is 24 months. Why under the foreign this one is 12 months?
I don't understand. What do you mean by 24 months? Where is that one contained?
So what
Do you have a rule in Nigeria that if you don't enforce a judgment within 24 months, you will lose the right to enforce it?
No. There's no rule applicable to that. But according to my own thing, the one I did there, but what I saw in my material.
That your material is misleading you. It's misleading you now.
Yes, sir.
We are all lawyers.
So,
what
yes,
is the
sir.
time you have to enforce a local judgment, a judgment obtained in Nigeria, which is being enforced in Nigeria?
According to what I have here.
Is it the section of the statute that says that, or a case law?
24 months. In the case of foreign judgment, it's 12 months. But under the provision of 2004 Act,
Sir, you are wrong.
6 years.
Sir, you are wrong.
Okay, sir.
You find the provision, you find the relevant guide under the limitation statute.
Okay, sir.
So what does the limitation statute say about 12 years or 10 years, depending on which state you are talking about? In a state like River State, for example, it is 10 years they start to see. But in Lagos, it is 12 years. Okay? So at common law, once the foreign judgment is recognizable, it enjoys the same time limit within which you must enforce it as the local judgment, as the judgment obtained in Nigeria. So common law is you have rights to sue upon it within 12 years or 10 years, depending on where you want to do it. Cap 175, you must do it within 12 months unless the court grants you leave. Cap F35, 2004, you have up to 6 years to do it. Although our courts have messed up the interpretation of Section 10A, as those who are talking about Kogbaya would educate us on. So go on.
So after that, I've also looked at Tulip's Nigerian.
You have 10 more minutes.
So in the case of Tulip,
which other case did you discuss? You have already discussed Tulip now. That's why you talk about definition of judgment. Even that Tulip said, did you understand what the court was saying? Did you understand it? Or you just quoted the court?
I quoted the court.
Anyway, don't let me waste your time. I will talk to it. I will speak to it next week. Go on. There are many cases you people discuss.
Yes, sir. I also look at Macaulay versus RZB of Australia, in which the court had turned up the time limit for applying for registration for both statutes. In 1922 ordinance prescribing 12 months, and the 1961 Act prescribing 6 years. The application
Okay.
for restitution was filed outside the 12 months, but well within the period of 6 years allowed by the later statutes.
Mm-hmm.
One of the issues that arose for consideration was whether the 1922 ordinance was extant in the light of the fact that it was not retained in 1990 lines. Compilation of the law of the Federation.
1990 LFN.
Yes.
Mm-hmm.
The line on Ibidapo versus Lufthansa airline. The Supreme Court held that the 1961 Act did not repeal 1922 ordinance. The ordinance must be an existing law recognized as such by Section 315 of the Constitution. The Supreme Court and the Council did not appreciate the two statutes were intended to govern were often to govern different scenarios, so that the question of one repealing the other ought not to have arisen in the first instance. The Supreme Court held.
Can you in your own language, that is Olaniyan's language, can you in your own language explain what Olaniyan was saying here?
So what the prof was saying in that stage is that the issue of the controversy between the two statutes wouldn't have even, they wouldn't have even debated. They wouldn't have gone far to the extent of stating that one statute repeal another, one act repeal another. Basically, that's what they are saying. That the basis of argument wouldn't have arisen from the first stage. From the first stage.
If what? Okay, take note. Class, you take note. Let me speak to that next week. Go on.
Okay.
Go on. What other case did you discuss? What other case did you discuss after ZB of Australia? I saw that you discussed virtually all the cases in my write-up now. And then you discuss Professor Lawoyin's review of VAP oil or something, VAP chemical petroleum. Yes. Go on. Okay, discuss at least 2 more cases from your write-up.
So in the case of, I'm looking at it because I'm using.
Okay.
In the case of Foluke Modashiru versus Ibrahim Abdullahi, the Supreme Court got it bearing right on the issue of lack of jurisdiction of foreign judgment as a basis for refusing to register a foreign judgment or setting the same aside. It is unfortunate to be treated that the two registration regime as if they were overlapped. The application for registration
regime overlapped. The people on Kogmaya, they have mentioned that one too. They will tell us. They will tell us why is it that we academics, especially me, it looks like I'm the only one who is hammering it, that in the first instance is an elementary error for you to be combining the two pieces of legislation together, or to be suggesting that one repeat the other. Because they are governing different situations. They are governing different situations. You can't even use the rule of construction that says latter statute repeal earlier one, because they are addressing different things. They are not. What do you call it? They are not cumulative. The two pieces of legislation are not cumulative. There is no country of the Commonwealth that expects that you enforce a judgment under either the ordinance or the statute. Rather, you will enforce the judgment. There is no Commonwealth country that assumes that you can enforce a judgment under either as an alternative. You must study which one relates to your judgment and apply it to use it to enforce. Okay. Sorry, I'm talking too much. Oh yeah, go on. I will talk to, remind me, let me talk to this next week. These are the areas that will examine you. Oh yeah, go on. You are a postgraduate class. You should be correcting our judges when they make elementary errors. Oh yeah, go on.
So yes, sir, there are series of cases, but I'm done with the one
There are so many cases you discuss. Most of them are from my write-up. Yes. But you also discussed some interesting cases from one particular interesting case is from Professor Olawonyi's write-up. What happened in that case?
I have another case here. Shona Johnson Limited.
Shona and Jasmine and all of them.
Omega.
Shona and Jasmine and all of them, they are all along the line of Macaulay and Azebi of Australia. Even the one that Professor Olawonyi discussed is along the same line. But those who are doing criticism, they should tell us why are we criticizing the Supreme Court and the Court of Appeal when they give those type of judgment. But go to Professor Adeo, the one that Professor Olawonyi discussed, VAP petroleum or something like that. Wow. What happened in that case? And what was Professor Olawonyi's critique of the case? Hello?
Yes, I'm looking for it. I'm looking for the case.
But me, I just went through it in about 3-4 minutes. And I can see what you wrote. You can't even remember. You just copied it. God will help us. Okay, if you can't remember that one, tell us anyone what happened in the Jackson case?
The Jackson case.
The Jackson case that you wanted to discuss before. I don't think it's different from the Macaulay, but if it is different, let's hear.
So in the Jackson case, the judgment concern was that is of the High Court of Justice in England, which is registrable under the 1922 ordinance. The issue was whether the lower court ought not to have set the registration of the judgment aside. The 1922 ordinance does not specifically provide for setting aside, but prescribe condition for refusal to register in section 2, which is identical to the condition for setting aside setting aside the prescribed in section 6 of the 1961 Act. It is the rule made pursuant to section 6 of the ordinance that permits the application for setting aside on the same basis as contained in section 3.2. The argument of counsel in this case was that since the appellant had notice of application to register the judgment, and he should have opposed the registration at the point instead of applying to set it aside, Mohammed JSC, in his minority judgment, thought it was unacceptable to rely on the rules to permit a party who could have objected to the registration of the judgment but choose not to do so, but to apply to set the registration aside. It is clear that the majority were greatly influenced by reference to section 6 of 1 of the 1961 Act, which was not applicable, though it is difficult to say if the outcome of the case could have been different if their lordship had known these facts. There are indeed fundamental differences between the two regimes with regard to the application.
Again. Let's see what paper 17 will tell us on that, and what Olania himself will come to clarify. Any other case? Is there any other case you looked at?
No, sir. That's the end of it, sir.
Well, you did look more than the few cases you have discussed. We encourage all members of the class to go through his paper, go through all the cases they reviewed, and try to understand the basis of either Olaniyan or Olawonyi's criticism of the cases before next week. Thank you. Time gone.
Thank you. Great to see.
Paper 17. Paper 17, you devoted a lot of time on criticism, if that is what you mean by quagmire. So can we have you talk to the criticism? Talk to the criticism of our own enforcement of judgment regime, whether registration or suing upon, which you have gathered from our statute and our cases. You have 20 minutes. Time is gone. Oh. Hello? Group 17.
Good evening, Prof.
Yeah, good evening.
Yes, my name is Olukunle Orimijuba, and I'm here with my other members of the group. I will be presenting on the enforcement of foreign judgments in Nigeria, and then we did a review of the relevant Nigerian statutes. So just the way you mentioned, we'll just go straight to the quagmire that we have mentioned in our paper. By way of laying foundation and following up on what the earlier group has said, we have two ways of enforcing judgments in Nigeria, which is the common law method for judgment, and also the registration regime, which allows for registration of foreign judgments without suing, filing a fresh action. But the situation in Nigeria is that under the statute regime, the registration regime, we have two statutes. First is the Reciprocal Enforcement of Judgment Ordinance of 1922, which is modeled after the UK law, and also the Foreign Judgment Reciprocal Enforcement Act of 1961, which is modeled after the Foreign Judgment Reciprocal Enforcement Act of the UK 1933. We have been able to dissect some of the issues that our courts have faced and even Nigeria faces in terms of recognition of foreign judgments. But I will quickly, if you permit me, to just read this quote. The quote is quite instructive in helping us understand what we try to cover in 20 minutes. So background to the review of judicial decisions. We said that in the words of Professor Lanion, there are many things wrong with the way the appellate and the apex courts in Nigeria have applied and construed the applicable law on the subject of enforcement of foreign judgments in the country. One of these is the prevailing assumption that Cap 175 of the Laws of Federation of Nigeria 1958 overlaps with Cap 7 F35. Another is the surreptitious abandonment of the option of enforcement of foreign judgments by suing upon the action, which is the common law procedure. The option will predate legislative intervention in the subject area and even circumstances where it appears to be the only option, without the benefit of coming within the purview of statutory enforcement regime, which clearly sets out defined limits of the extent to which the courts can enforce. The courts of the enforcing country may interfere with judgments of foreign forum. Such judgment can only be enforced by commencing actions in common law actions. So what Prof is saying here is that, yes, Nigerian courts have acted exclusionarily towards the common law way of enforcing foreign judgments. And sometimes we find that the court, even in undeserving cases, tries to force itself, to apply either of the two statutory provisions, vis-a-vis the FJRA and the REGO. So in order to do what Prof has said, we said that the foundation of, in this research work, we believe that there are two aspects of the quagmire. The first is the legislative, and then the other is the judicial quagmire. By legislative quagmire, we try to say that the Nigerian law on the subject is in a state of confusion. What do we mean by that? First, we said that the inadvertent omission of the 1992 ordinance in the Law of Federation of Nigeria since the review from 1990 to 2004 to 2014 and the rest of them the RIJO, the Reciprocal Enforcement Ordinance, has been missing. It has not been, republished. Therefore, leading to confusions as to whether or not the law is still extant, by the fact that people don't consider it to be authentic, because you have to look at older laws to see it. And then the law is also obsolescent in certain respects. For example, the RIJO talks about Commonwealth countries and make mentions of states that no longer exist. Make mention of states like the Gold Coast of Ghana and the rest of them. And then issues have arisen even in courts in Kenya, like the ITAL case, where the court in Kenya refused to enforce the judgment of the High Court of Tanzania when their own copy of our own law, the RIJO, says that the High Court of Tanganyika. So the reality on this on ground is that the law is obsolete because it no longer takes care of the realities of countries and the world order. Also, in relation to issues about the courts, you find some of those the acts making assertions to the Supreme Court of Ghana or the Gold Coast of Ghana. There are other courts, so it's giving suggestions that High Courts of Ghana, for example, their judgments cannot be enforced as common law judgments under the ordinance. And then those other issues are there. Then we also have the implication of the provisions of Section 3 of the 1961 Act. So Section 3 of the 1961 Act, that is the section that empowers the minister, the relevant minister, which in this case is the Minister of Justice and Attorney General of Federation, to extend the reciprocity of the Act registration regime to any country with which Nigeria has a bilateral agreement extending same privilege to Nigerian judgments. But as at now, we find that the minister, even after over 60 years of the law, is yet to make any extension, or by putting in a gazette extending that powers or the ability to register under the 1961 Act to any country in particular. And that can be seen in cases like the case of Macaulay and RZB Australia, where the court made allusion to the fact that the 1961 Act remains inchoate because of because of the lack of extension by the minister. Another cases like Marine and General Assurance Co. PLC versus Overseas Union Insurance Limited, as well as Wheat and Bush Limited versus Dale Power Systems PLC. The court made it abundantly clear that the 1961 Act is inchoate and inapplicable. And Ll.M said that this thing will lead to confusion. Later in the future, in the case of VAR Petroleum Incorporated and Mr. Mike Moma, that case confirms Ll.M's prediction, where the Supreme Court went ahead to apply the provisions of Section 60 of the Act in determining whether a court has properly applied as properly assumed jurisdiction to entertain the matter in the first place. Then there's also the problem, one of the legislative comments is the problem of the inelegant drafting of Section 10 of the 1961 Act. The provisions of Section 10 of 1961 Act, I will discuss them later, or maybe I should just discuss them now, or I'll discuss them when I'm discussing.
Discuss them now, please.
Okay.
Don't postpone anything.
Okay, so the provisions of Section 10 of the 1961 Act is a provisional provision that allows that. I want to read the particular section so that the class can exactly follow what I'm saying. Or let me just summarize the section. The section is saying that there's a possibility of enforcement of judgments emanating from states which have reciprocity with Nigeria, provided that those judgments were still within the time frame of 12 months,
Section 10A.
Yes, Section 10A of the 1961 Act, which is the Foreign Judgment Reciprocal Enforcement Act. that it is still possible to register that judgment, within 12 months, even though the court in one breath has said that the provisions of 1961 Act are not applicable because they are inchoate. The court still said that because of the provision of Section 10A, that there's a possibility of registering that judgment if the judgment comes within a period of 12 months. Even in cases where it has already thrown away the act, thereby precipitating some sort of confusion on whether or not, if a judgment is brought within in less than 12 months from the date of the judgment can be enforced. In order for us to be able to properly dissect the error that the courts have made by that allusion, we try to look at the Singaporean version of the same provision of the 1961 Act. And based on our own analysis, we found that the intendment of that provision really is that if the judgment was made 12 months before the coming into effect of that act, and the act will not come into effect unless the minister makes the extension. So if the judgment is made 12 months before the coming into force of that act, although it doesn't meet the exact date of the force of the act can still do some retrospective application of the act to earlier judgments that are less than 12 months old or exactly 12 months. But it does not follow from what the courts have said, for example, in the cases I've highlighted, that once the judgment is less than 12 months old, then it can be registered under the 1961 Act. This is truly a misunderstanding of the provision of Section 10A, because if the minister does not make the extension of that law to that particular country, then the issue of activation of the 12 months period under Section 10A does not even arise, because Section 10A will only be given life when the minister does so, or when there's a bilateral agreement between Nigeria and the other country. Okay.
Good. You really you understood what you are saying. Many people will just copy someone's opinion without understanding it, but it appears as if you understand what you are saying. But we'll still revisit it again next week. Very good, very good. Yes, you also talk about dual regime. You said something was wrong with our courts presenting as if the two pieces of legislation are cumulative.
Yes, very important. The cases that we have highlighted in this work, particularly the case of Grosvenor Casino and Gasang Alui, as well as the case of Macaulay and RZB Australia, when the issue turned upon the time limit for registration of judgments, and even in some other cases where the issue turned upon the time limit for application for a cancellation of registered judgments, and then on the amount or whether local currency or foreign currency is to be used in ascertaining the liquidated money demand in a foreign judgment. The court made allusion to the fact that, you could have either have brought it under the 1921 Ordinance or the 1961 Act. But that position is also untrue, because our analysis of the subject shows that the 1921 Ordinance applies to Commonwealth jurisdiction by virtue of Section 3. Section 5 of the ordinance. The ordinance permits the Governor General to extend application of that ordinance to other Commonwealth jurisdictions, apart from those that have been expressly stated in the schedule to that ordinance. Now, that law applies strictly to Commonwealth countries, first in the ordinance, and those that it has been extended to. However, the 1961 Ordinance, which is a prototype of the 1933 Act in the UK, was as a result of agitation by merchants and lawyers and solicitors alike, saying that we only have registration regime within the Commonwealth countries. The world is becoming a global village, and it will be important to have that regime extended to other countries that are not within the Commonwealth. So that was what gave birth to it. Therefore, making the 1961 Act applicable to all countries, whether Commonwealth or not, provided that they have a mutual agreement with Nigeria. And Nigeria's Minister of Justice has extended reciprocal application by publishing in a gazette, that's extension to that country. So it's either you take one or the other. But if you are a Commonwealth country, you can come under the Commonwealth Ordinance of 1922, provided your name is enlisted in the schedule to the Act, to the ordinance at the time, or if the minister, as the Governor General, has extended application to you, or the 1961 Act, if there is a mutual agreement between your country, even though you're a Commonwealth country, and Nigeria, so that the advantages, for example, of the time limitation for registration of judgments, which is a bit more liberal under 6 years under the Act, will be applicable to you. But you cannot cherry pick. You cannot say, this applies to you and this applies to you, because for all intents and purposes, the 1961 Act remains inapplicable, because apart from the fact that the minister, there's no country with which we have a mutual agreement, the minister has still not, made any gazette, extending it to those countries. So I think it's also a problem, a judicial problem, where the courts begin to treat 1922 Ordinance and the 1961 Act as though they overlap. So that's the other issue.
Fantastic presentation, but you didn't talk about Section 9, subsection 2 of the CAPEF 35. If you look at Section 9, subsection 2 of CAPEF 35, you see that is the real reason why the court should understand that the legislature did not forget anything when he failed to repeal the earlier act. Yes. Can you remember what Section 9 of Section 2 says? Okay, I will talk about Section 9 of Section 2 next week. Go on. So that we can make progress. Mm-hmm.
So we have said that that's about most of the work that you said we should focus on. Yes. Then, except to now proceed to the summary and then what we think the solutions should be to the quagmire. Is that okay, Prof?
Did you discuss the seeming conflict in our case law on certain type of issues that will often arise? Yes. For example, you have people who will be the court of the foreign judgment would have assumed jurisdiction over them. They were here in Nigeria. Somebody went and filed an action abroad. The person now used their own equivalent of our Order 10 Rule 1 to summon them. It's either they didn't appear or they appeared on protest. And then the court dismissed their protest and went ahead to deliver judgment against them. And that same judgment is a judgment that needs to be enforced in Nigeria. Now you find occasions where the Nigerian judgment debtor we struggle to say that Nigerian court should not recognize or enforce the judgment. Occasionally, the Nigerian court will agree. Another time, depending on the mood of the judges, they will say, no, but that's an issue that has been resolved now. That's an issue that has been resolved abroad. If you look at the case of 21st century, you compare it with what the court did in the case
Grosvenor
of
Casino.
Gaza Alawi.
Yes. We did that, sir. We discussed it. Should I go over it again, Prof?
What is your take and what is your reason for taking your position?
Okay, so our position in relation to jurisdictional conflict is that, jurisdiction is a fundamental issue in Nigeria and it can be raised at any time. But our law for impersonal action most of the time, our law is the writ rule. The writ rule says that when you find the defendant, whether in transit or permanently residing within the jurisdiction of the court, which is also known as territorial jurisdiction, The court will have jurisdiction to entertain the matter as of right, which we also know as the mandatory jurisdiction rule. Now, Nigerian courts, for example, in the case of Teleglobe America and 21st Century that you mentioned, when the defendant raised the registration of judgments in Nigeria, the court said no, that the issue of jurisdiction has already been raised in the foreign court and it has been decided one way or the other. So it cannot be a basis upon which the court is going to refuse registration of the judgment. But in another breath, in Grosvenor Casino Limited and Gassan Alui, the court said that the Supreme Court, following the Court of Appeal, dismissed, the appeal because the High Court said that he had already acknowledged service. So he cannot come and raise any issue. He acknowledged service and he cannot come and be saying that, they did not serve in process according to Nigerian rules. But the Court of Appeal said no, that he was not properly served and that a protest appearance might not necessarily amount to voluntary submission to the jurisdiction of the court, and therefore the court said that the judgment could not be registered. So that is one of the that's one of the issues that we had raised, that in one breath the court is saying, the matter has been dealt with in the forum, in the foreign court, and here the court is also saying that if he was not properly served or if he has protested, by submitting.
Which of the two approaches are correct?
So
if nobody really understands what this whole issue is all about.
So I believe that the decision in Grosvenor Casino Limited is to be preferred. The reason is that the issue of jurisdiction is fundamental, and it is not enough to follow the civil procedural rules of the foreign courts. If under Nigerian law, just as we follow it in the common law procedure for enforcement of foreign judgments, if under Nigerian law, jurisdiction has been wrongly assumed, is a base upon which the courts can refuse registration of that judgment. So I believe that the second case of Grosvenor Casino Limited is to be preferred based on our extant law right now, sir.
Very well. I may repeat this next week, but whenever I'm arguing this position, I will go back to the theoretical basis of enforcement of foreign judgment. Now, if we are using committee, those who spoke to us on theoretical basis, they talk about committee and they talk about obligation. If you are relying on committee as your basis, then you will say that the reason why you are enforcing the judgment of another country in your own country is because that is what you expect the other country to do if a judgment is obtained in your own country and sought to be enforced in their own. So even though the cases tend to deny it, but the real reason for committee as a principle is reciprocity or mutual respect. And so if you are talking about reciprocity or mutual respect, yes, you can situate the practice where you don't even ask questions. You just take as giving answers, the answers that have been given abroad. But as opposed to doctrine of committee, we have doctrine of obligation. The doctrine of obligation would say that we are not enforcing that foreign judgment because of mere respect to the other country, but because we are treating the judgment or award against you as a debt which you are obliged to pay. When are you obliged to fulfill a debt? We want to be sure whether that foreign state had exercised proper jurisdiction over you. And so both the common law regime and the statutory regime will impose conditions. The doctrine of obligation it is that permits the forum where judgment is sought to be enforced to raise questions which will qualify that judgment for enforcement. And whether you are coming under the statutory regime or under the common law regime, questions are raised. One of them is the jurisdiction of the foreign court in entertaining the case. And whether it is common law or statute, it is said that the foreign court must have entertained, must have had internal competence as well as jurisdiction in the international sense. In other words, you cannot drag someone. You see, in the case of Skisby and Western LS, that those who are talking about obligation mentioned, that was exactly the issue there. Somebody was reached through assumed jurisdiction, identical to our own order 10 rule 1. Okay, notice of it was served on him where he was. Okay, and judgment was then obtained against him, and it was that judgment that was sought to be enforced in England. And the argument of counsel who wanted to enforce the judgment at common law was that, look, there's nothing strange. There's nothing strange about summoning people who are outside the territory of the court where the case went on. We also have it in our rules. So the person then referred to the relevant order, Rule 1 of Order 11 of the Old English Supreme Court to say what they did is what we would have done. You know what the English court said? The English court said, even we, when we are doing it, we know that we are exercising exorbitant jurisdiction. Exorbitant jurisdiction, because we know that if another country had summoned someone in our territory like that, we will not enforce the judgment. So the English court demarcated clearly between the basis of assumed jurisdiction and the basis of recognition of judgment. Okay? So going forward, under a doctrine of obligation, a foreign court is entitled to prescribe conditions upon which it will recognize a foreign judgment. And so for a judge to say, this issue that we had dragged was raised and the American court had given judgment and that's the end of the matter, is to appear to be following a committee principle. Okay? The committee principle is no longer in vogue. The real principle is obligation. And that is why the statutes go ahead to prescribe conditions. How can a judge say that because you raise the issue and the American court, looking at our own internal law, says everything was all right, then we now ignore the provision of our own statute? What does our own statute say? Our own statute in the relevant section prescribe conditionalities. At least one of which must be met in order for the American court to have had jurisdiction. So if none of them was met, there was no basis for recognizing the judgment. And if somebody raised an issue, you cannot say that because it's identical to an issue that was answered by the American court, therefore our own court should not look at it. That is wrong. Whether it is a statutory regime or it's a common law regime, the doctrine of obligation requires that our own court should prescribe our own condition for recognizing the foreign judgment. And if that condition was not met, our court is then qualified either not to recognize the judgment or to set aside its registration. So that is the reason why there are two reasons, there are two things that are wrong with the Teleglobe judgment. The first one is even very basic. The second one will require you to understand the doctrinal basis of enforcing other countries' judgment, like I've been arguing. But the first one, which is basic, is that a legislation regime is a product of treaty. It's a product of treaty. You will not find any other Commonwealth country register a judgment from America. Why? The reason is that America does not do treaty with anybody to give registration, to register a judgment. Not even Canada, that is the next door neighbor. America does not enter into reciprocal enforcement judgment arrangement with any country. So anybody who has a working knowledge of the subject area will know that a judgment obtained from America is a no-go area for registration. And that is the question I was asking my papers. What happened to the common law regime? Because the common law regime of springing upon the judgment does not bother itself about where you have obtained the judgment. If you met the requirement of recognition, and the judgment is a judgment for payment of money fixed or ascertainable, the common law court everywhere will go ahead to give you a fresh judgment upon the judgment you have obtained from that foreign country. So if the bar and bench in Nigeria understand this, forgive me to say elementary point, the lawyer who is trying to accumulate his chance by seeking to enforce judgment under a combination of F-35 and Cap 175 should easily have sued upon the judgment. He should easily have sued upon the judgment because the common law basis of enforcement remains. The 1961 Act is the one that says if you have such a reciprocal arrangement with a country, then it defeats any attempt to come under the common law. But we have not entered into it with anyone. The minister has not made any order. And so why exhibit sheer ignorance, in my own view, by saying you want to combine two pieces of legislation that are not combinable, when the common law basis is there? If you seek to sue upon a judgment, irrespective of where it is obtained, which is the common law method, all you need to do is meet the requirement for recognition, and show that it's a judgment for a payment of a sum of money, and the judgment given by a civil court. You are able to do that, you have already satisfied the common law basis, and the foreign judgment constitutes res judicata, in the sense that the Nigerian court will not go over it again. So why gamble? That's my one worry in my paper. Why gamble if you understand the regime very well? Why not sue upon the judgment instead of saying you want to use a combination of Ordinance 175, Ll.M 1968, and F-35. And if you go and look at Section 9 of Section 2, you will get the point we are making. The British government never intended that at the point that the 1933 regime will be extended to any Commonwealth country's judgment, that the Ordinance of 1922 will still be in force. The Ordinance of 1922 was expected to wind up gradually as the British government, on a piecemeal basis, continue to make reciprocal arrangement with other Commonwealth countries, upgrading their relationship to the 1933 regime. So, but the Nigerian courts, they make a mess of themselves by allowing counsel to say, okay, I want to use Section 3 of Cap 175, I want to merge it together with section 8 of Cap 35. Where is that done? And that is the real reason why we are making a money out of molehill of the fact that the 1961 ordinance did not repeal the 1922 ordinance. It was not meant to repeal it. It was not meant to repeal it. The two were meant to exist as separate regimes. And so the very first inquiry that a person who knows the subject area was supposed to do is, where was this judgment obtained? Which reciprocal arrangement did we have with them? It's not even all Commonwealth countries that will enjoy 1922 ordinance. No, it's not all of them. Just about, apart from Ireland, England, and I think Scotland or so, the other Commonwealth countries would have to have gone into some treaty with Nigeria. And there are about 10 or 11 other Commonwealth countries like that. Outside of those 10 or 11, the rest, you can't enforce their judgment by even 1922 ordinance. Then the 1961 Act, that one is even a laughable thing. How our courts manage to create an opportunity to enforce any judgment under that act is still one of the wonders of the whole world. Because it's like putting the cat before the horse. And it is that type of error that will lead the court to say, come and register an American judgment. And then the other Commonwealth countries will be looking at us and be laughing. The common America, you say reciprocal basis of legislation is reciprocity. Where will America allow you to come and register a Nigerian judgment in America? But the lawyer came without a thorough understanding of the subject and sought to merge two pieces of legislation. And the judiciary that really was not thorough in his understanding of the subject thought that Section 10A could apply. And since that mistake was made, for God's sake, we've been crying. You can see what Olawoyi said. You can see what I said. Tomorrow, if the matter comes up again, the same mistake will still be committed. The same mistake, and they are elementary errors. They are very elementary errors. If you go and read Section 9 of Section 2, you will see that it's not possible. It is not possible for Cap F35 to govern a foreign judgment, and for Cap 175 to also govern it. The two of them can never cumulatively govern a judgment. It's one of the two. And that's what I was emphasizing, that you see that the regimes are different. For the 1922 ordinance, you file a petition and you will serve, so that the other party will have the opportunity to oppose your plan to register the judgment. So it is at the point the judicial function is the very first act that the court will perform, because there will be fireworks. The man who is seeking to enforce it and the man who is objecting to it will both raise their judgment, argument, and the judge will give a judgment. So you do not expect somebody to come later to say the thing you would have said at the time you were applying and you serve it, to come and use it to set aside the thing. But on the other hand, the 1961 Act, the role of the court is administrative up to the stage that somebody applies to set aside. Once you provide a certified true copy of the judgment, the court looks at it that the date when the judgment was obtained was still within 6 years. The court looks at it that it has met all of the other requirements. Boom, it will register it. But that's not the end. The court will now serve the other party notice of the registration. And then the other party is now supposed to come to apply to set aside. So there are two different regimes. But what our judges will just do is, without thoroughly reading the two regimes, they are procedurally different. They serve different purpose. They apply to judgment of different countries. But Carter will just come. He will argue section 2 of 1 together with section 6 of the other. Where is that done? Where else in the whole of the Commonwealth is that done? The basic error. Okay? Anyway, this is what I ought to have been saying next week that I've started saying. Can you conclude? So we will take the people paper, I think it's paper 20, isn't it? Hello?
Yes, paper 20.
Paper 20 will have to be next week, but I will talk to paper 19 so that if they want to score any mark, they should go, even if it is just those two sections, they just look at intelligently. They will still score a mark, but whatever I think that they have said correctly in their paper is irrelevant to me, because what we want them to discuss is the enforcement of sister state judgment, not a service of sister state writs. And it does appear as if they were discussing obtaining leave and all of that. There's nothing like obtaining leave in enforcement of sister state judgment. What section 104 simply says is that if you obtain judgment in Kano and you want to enforce it in Lagos, obtain a certificate of the judgment. I'll be surprised if there's any one of us who doesn't know what a certificate of a judgment is. Is the certificate true copy of the judgment now? Obtain it. Obtain it from the court where you have obtained the judgment. Okay? Unlike enforcement of foreign judgment, where you have several grounds for setting aside, Nigeria Interstate operates what looks like a full faith and credit arrangement as operates in America. We will not permit you to use some of the things you use to set aside a foreign judgment. Don't come and use it at the interstate level. So all that is required of the judgment creditor is obtain a certified true copy of that judgment. Nobody goes into the merit any way, in any manner. At least for foreign judgment, we have seen now that our statute will set condition. Common law too will set condition. And you can use non-compliance with those conditions as a ground either to refuse recognition or to set aside registration. But in the case of interstate, nothing like that. If you obtain the certified true copy, which section 104 calls certificate of the judgment, it is already given that there's a judgment. Nobody questions anybody. Then what does he do in the state where he wants to enforce it? There is a book called Register of Nigerian Judgment. Every state has it. So you apply to enter that judgment into that book. Go and read section 105, subsection 1 and 2. Once you do that, for all intent and purpose, that judgment has become the judgment of the state where you seek to enforce it. That's all. That's all that we want you to say. All of those things you are talking about, leave and all of that, they are not relevant to enforcement of judgment. They are not relevant for enforcement of judgment. Leave is only relevant for leave is necessary if you obtain a writ from a federal high court and you are serving it outside of the state where you obtain it. Leave is not even necessary if it is a state high court. What you need to comply with is section 97 and or 98 or 99 of the Sheriff and Civil Process Act. Please, these things are basic. Understand them. As basic as they are, our court and our lawyers make elementary errors on them. So go and look at section 104 and section 105 again. Okay? They treat the subject of interstate enforcement of judgment. Okay? No, the question of leave is there is nowhere there where they ask for leave. Okay? The cases you are talking about are not cases on enforcement of judgment. They are cases on service of writ. Okay? And the position with service of writ is that if you obtain the writ from the Federal High Court, the Sheriff and Civil Process Act does not apply, but the civil procedural rules of the Federal High Court will apply. And the civil procedural rule of the Federal High Court will tell you that you need to obtain leave. So if you will come and obtain, if you will come and obtain writ of the Federal High Court Ikoyi, and you want to serve it at Ijebu-Ode or Ibadan, you will have to ask for leave. If it is the writ of the Lagos State High Court you are obtaining, you don't need to ask for leave. Just make sure that it's specially endorsed. Because Section 96 of the Sheriff and Civil Process Act says that it will be served in Ijebu-Ode or Ibadan as if it is being served in Lagos. Okay? Or as if it was obtained in Ogun or your state. That's what Section 96 says. I remember that the people who presented paper on interstate jurisdiction too, they didn't satisfy us. So they can also use this opportunity to rewrite a paper, because I'm going to assess each of those seminars and I'm going to assess them based on the substance you say. Okay? So paper 20 will give you 20 minutes next week. And thereafter, I will use another 40 minutes to discuss to go over enforcement of foreign judgment. And thereafter, before we come next week, I would have settled on what area we are examining and wish you best of luck.
Thank you so much, Prof.
Thank you,
Thank
Prof.
you,
Prof.
Prof.
Good night.
Prof.
We have taken all the hints, sir. We are very
Thank
grateful,
you,
sir. We
Prof.
will do the needful. Thank you for the indulgence, sir.
Yeah.
Ẹ̀gbọ́n Victor, wà á kálẹ̀, iṣẹ́ ń kọ́ sà, ẹ pẹ̀lẹ́. Ẹ̀gbọ́n yín nǹkan tó ń lo Vox yẹn, that's like how, brother.